Employee non-competes are now banned. Is the employer non-compete agreement going away? Here's what I know. On July 9, 2021, an executive order was issued by the President that instructed the Federal Trade Commission, the FTC, to use its statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. On January 5, 2023, the Federal Trade Commission announced a proposed regulation that, if adopted, would essentially abolish employee non-competes across the United States. Key features in the proposed legislation include the following: banning employee non-competes in almost all circumstances. Keep in mind that the legislation would not apply to other types of agreements with employees, such as non-disclosures or customer non-solicitations, unless they constitute a de facto non-compete agreement. Employee non-compete agreements would be illegal both moving forward and backward, according to the proposed regulation. Employers who already have non-competes on file for employees would have to revoke them and notify current and former employees that they are no longer in force. Inconsistent state regulation is supposed to be preempted by the proposed regulation. In other words, the FTC regulation would forbid the non-compete provision even if it is compatible with and enforced under state law. As of this recording, there are 9 states staying ahead of the curve by enacting their own significant barriers on the use of employee non-competes. States that erroneously require employees to sign non-compete agreements face civil and sometimes even criminal penalties, which employers should be aware of, especially if your business is headquartered in one state and employees work in any one of these states. California. In California, non-compete agreements are prohibited by law, and employers cannot require employees or applicants to agree in writing to any term or condition known to be prohibited by law. California employers who violate the ban may be found guilty of a misdemeanor and either fined up to $1,000, imprisoned up to 6 months, or both. Colorado. Entering into, presenting to an employee or prospective employee as a term of employment, or attempting to enforce an unenforceable non-compete agreement is a violation of Colorado law. An employer that uses force, threats, or other means of intimidation to prevent any person from engaging in any lawful occupation wherever the person chooses to work may be found guilty of a Class 2 misdemeanor. An employer may also be liable for actual damages and a $5,000 penalty per harmed employee or prospective employee. Illinois. Illinois law establishes various non-compete restrictions, including an income threshold. For violations of the non-compete restrictions, the Attorney General may request and a court may impose a civil penalty not to exceed $5,000 for each violation and $10,000 for each repeat violation within a 5-year period. Maine. Maine law establishes an income threshold and various notification requirements, among other things. Employers who violate these requirements may be found guilty of a civil violation and can be fined a minimum of $5,000. Nevada. Nevada law establishes an income threshold and various other requirements for employers who enter non-compete agreements. Employers who violate these requirements may be guilty of a gross misdemeanor and fined up to $5,000 for each violation. In addition, the Labor Commission may impose against each culpable party an administrative penalty of not more than $5,000 for each violation. If fines or administrative penalties are imposed against an employer, the employer may also be liable to pay for the cost of the proceeding, including the investigative costs and attorney's fees. Oregon's non-compete law is part of the state's minimum wage laws. It does not state how or if the law can be violated. Instead, it merely states that a non-compete agreement is void and unenforceable if various requirements are not satisfied. Per the state's catch-all statute regarding its minimum wage laws, a violation constitutes a misdemeanor. However, it is unclear when, if ever, entering an invalid non-compete agreement gives rise to a misdemeanor. Virginia. An employer violates Virginia's non-compete law by entering into, enforcing, or threatening to enforce an invalid non-compete agreement with a low-wage employee. Employers who violate these restrictions may be subject to a $10,000 civil penalty for each violation. Virginia law also creates posting requirements. An employer who fails to post the non-compete law in the workplace will be issued a written warning for the first offense, a civil penalty not to exceed $250 for the second offense, and a civil penalty not to exceed $1,000 for each subsequent offense. Washington State. If a court or arbitrator finds that a non-compete agreement violates Washington's non-compete law, the violator may be required to pay the aggrieved party actual damages or a statutory penalty of $5,000, whichever is greater, along with reasonable attorney fees, expenses, and costs. An employer seeking to enforce a non-compete agreement may be subject to this penalty even if a court or arbitrator reforms, rewrites, modifies, or partly enforces the agreement. Washington, D.C. Washington, D.C.'s non-compete law establishes an income threshold and various notice requirements. Employers that violate these restrictions may be subject to an administrative penalty between $350 and $1,000. Moreover, an employer that attempts to enforce an unenforceable or void non-compete provision is liable for a minimum penalty of $1,500 to each employee against whom the employer attempted to enforce the agreement. An employer that violates the notification requirements may be liable for $250 for each violation to each employee subjected to the violation. Wisconsin. Under Wisconsin law, a non-compete agreement that imposes an unreasonable restraint is illegal, void, and unenforceable. But non-compete agreements are otherwise lawful so long as they are reasonably necessary to protect the employer. Under a catch-all statute that imposes fines for violations of Wisconsin employment regulations, an employer that violates the state's non-compete law could be fined between $10 to $100 for each violation. Note, however, that this catch-all penalty statute does not currently appear to have been enforced for non-compete violations. Nothing is going to happen right away. Despite the significance of this announcement, the proposed federal regulation must still be implemented through a number of steps. Businesses and others interested in providing feedback on the proposed regulation will have 60 days to do so after a formal notice of the proposed rulemaking is published in the Federal Register. The FTC will then prepare a final rule. By then, litigation over the rule's legitimacy is more than likely going to happen. There will be at least 6 months implementation grace period. Businesses that are concerned about proposed regulation should think about submitting comments to the FTC to explain why they disagree with the rule. This non-compete situation is changing quickly, especially since each state is starting to implement their own version of this proposed federal legislation. Employers, stay alert and consult with your company's licensed employment attorney for more information. If you want to know more about business operations, business management, human resources, and other topics related to running a business, click on one of those play links. Click on one of these Click on the playlist.
One eternity later.
Click on one of these playlists. Thanks for watching. And don't forget to subscribe.